Good morning once again. The topic assigned was basically, on the recent nine-judge bench judgment of the Honorable Supreme Court in MADA. MADA is nothing but Mineral Area Development Authority. This is from state of Bihar versus SAIL, SAIL, Steel Authority of India Limited, and another. A lot of parties involved in this petition. The same matter, it was decided, we have two judgments, one on 25th of July 2024 and another on 14th of August 2024. Now, not very regularly we get to hear, nine-judge bench being formed, and the two of the Honorable Supreme Court. Generally, it is two or three benches, three-judge benches continuing. The moment it's five and above, basically it is a constitution bench under the powers of the Constitution given to the Chief Justice, and he formulates a Constitution bench on any matter of law, or sometimes if there is a reference given by two or three judge bench. So that is how this Constitution benches are formed, five and above. It could be 5, 7, 9, 11, and 13. So that's how it goes. Now, this judgment, it is not directly a judgment on a tax matter. This has got something to do with the mineral legislation. This is something to do with the royalty payments done by the leaseholders. It is something to do with the land laws in the country. So across, and of course, it has got something to do with the powers vested in the central and the state governments under the 7th schedule of the Constitution. Now, of course, we are an allied group because recently, I think end of September, I had an occasion to discuss the same judgment in front of certain leaseholders, a couple of hundred leaseholders, because there the focus was different. Now, this is a very closed group and a well-learned, erudite group, I would call. So here the focus is something different. So I hope to complete the presentation in the given time, that is 2 hours. I think today only I have been asked to present. Hopefully we should complete in the next 2 hours. Suppose something remains, we will definitely take it up in the next session, not a problem. So I hope I have the privilege of going a little slow so that we can drive across the points. Even though this is something related to mineral legislation, something related to the land laws. But yes, we are students of law, and anybody wanting to interpret the legislative powers given to the state or central government, especially list 1 and list 2, mandatorily has to go through this 9-judge bench order. If somebody doesn't go through this 9-judge bench order, that means his understanding is little, lacking somewhere. Because whatever the interpretations we carried, in fact, my own personal experience, certain interpretations we had, again, legal jurisprudence evolved by the Supreme Court over a period of time. For the last about 30, 35 years, everything has been demolished. Everything has been demolished now. 25th of July 2024, we have to look at the entries in the 7th schedule. We have to look at the legislation powers, we have to look at the provisions of the mineral laws in a very different angle going forward, because 9-judge bench and it's the law of the land. So this is the background. Now, first of all, before I actually jump into the judgment, I want to give you a small background for everybody to understand little bit on the mineral laws. We have to know, because without knowing this, I can't directly go into the judgment. Now, first of all, mineral legislation, we had something called as the Mines and Minerals Regulation and Development Act 1948. This was implemented with effect from September 1948. That means this is before the Constitution was enacted. We all know Constitution was enacted in 1950. So this law we had even before the Constitution was enacted. Subsequently, this was repealed. So we had something called as MMRD, Regulation and Development Act 1957, with effect from 1st of June 1958. Then what happened in December 1999? They just changed the name. The government thought, no, we should develop first and then regulate later. So that's the reason they just renamed. They renamed it as MMDR Act 1957. This is from December 1999. This is a little background because we keep using the terminology as MMRD Act or MMDR Act. So this is the background. Now, of course, you have the enactment. This is the act. Then you have a host of rules. So a little bit we'll look into all of them. Now, the contents of the MMDR Act, basically it has got about 59 sections divided into three parts. Part 1, Part 2, Part 3. Not only me, there was one judgment of the Honorable High Court of Karnataka way back in 2011. They also looked into the provisions of the MMDR Act and they said it can be easily divided into three parts. If you see Part 1, Section 4 onwards, that means Section 1, 2, and 3 is not covered here. No, generally section 1 is basically, it says, the date of implementation and it's applicable to which part of the country or to the entire country. Section 2 and 3, we'll look into it in a moment from now. Now, 4 to 17A, it talks about regulation of mining of minerals. There are only two sections that talk about development of minerals, and then the balance, they're all miscellaneous matters. So basically, we divide them into three parts. Now, applicability, obviously it applies to all minerals other than mineral oils. Now, minerals, definitely when we are talking about minerals, we should know what is a mineral. It says it includes all minerals except mineral oils. Now, what are mineral oils? Mineral oils include natural gas and petroleum. If you go to section 9 of the CGST Act, section 9 of the CGST Act, there also petroleum products are out of the purview of CGST Act as of now. Of course, apart from alcohol, for human consumption, we have this petroleum products and now ENA, extra neutral alcohol. They are outside the purview of CGST Act. So something similarly, you can draw parallels. Even here, MMDR Act, it is applicable to all minerals other than mineral oils. That means natural gas and petroleum. Draw parallels. Now, of course, if you go to para 21 of this 9 judgment, it says, it has defined, it says a mineral, it says is an inorganic substance and they are non-renewable resources. One to excavate, matter ends there. There's a void created. Nothing can be done. It cannot be renewed. So they've looked into the definition. Now, where is the power? Where is the power to enact MMDR Act? Obviously, we go back to the Constitution, 7th schedule. If you go to entry 54, list 1, this is the entry the Supreme Court, the Honorable Court has interpreted in this whole 9-judge bench order. Now, entry 54, it says regulation of mines and mineral development to the extent to which such regulation and development under the control of union is declared by Parliament by law to be expedient in public interest. The exact wording in Inter 54, list 1, it says regulation of mines and mineral development under the control of union declared by Parliament by law. So that means the central government, by virtue of this entry, the central government can legislate. Now, it says declared by Parliament by law to be expedient in public interest. Now, what the central government has done is they have enacted MMDR Act. They've gone to the Parliament and got it passed, and to give the declaration, it has mentioned the declaration to the expediency of union control in section 2 of the MMDR Act. Now, it says section 2, it says it's hereby declared that it is expedient in the public interest that the union should take under its control the regulation of mines and development of minerals to the extent hereinafter provided. Now, generally, you take section 2, by and large, any legislation in India will always have definition. Like section 2 of the CGST Act, IGST Act, Income Tax Act, it's always definitions. But here, section 2, they have to come up with the declaration. Now, there is a reason behind it as to why section 2 has this declaration. Now, section 3 has all the definitions in the MMDR Act. So that is a little change when compared to the other tax laws. Now, if you go to entry 23, list 2, entry 23, list 2. Now, what is list 2? Of course, the members are aware. I don't have to explain. Now, entry 23 also talks about regulation of mines and mineral development subject to the provisions of list 1. with respect to regulation and development under the control of union. That means we have two entries, one in entry 54 list 1 and the other entry 23 in list 2. But entry 23 list 2 is subordinate to entry 54 of list 1. That means to the extent the central government has already enacted a law, the state cannot enact. The state cannot enact because our constitution, it gives primacy to the union list. The central government, the federal structure has got more importance when compared to the powers given to the state governments. So, to the extent MMDR Act has already covered the field of regulation and development of minerals, the state government, no state government can come up with a new enactment. So, that is the interpretation. Now, entry 54 and entry 23, list 1 and list 2, we have covered. Now, obviously, things were litigated. So, in one of the landmark cases, it's a landmark case. It's our own case from Karnataka. The matter went up to the Honorable Supreme Court. It is in the case of Sander Manganese and Iron Ores Limited versus State of Karnataka, wherein they have said, by virtue of Section 2, the state legislature is denuded of its legislative powers to make any law with respect to mines and minerals. Once the central government has taken powers, sorry, you don't have any powers. And they clearly say the state having any power to frame a policy DRs the MMDR Act and the rules is not available. So what happens generally, we know all the state government, they conduct this global investors meet. Like every 2 years or 4 years, depending on the state, like Gujarat, Karnataka, so many states. Now Uttar Pradesh has also started. They conduct this global investors meet. And then, a lot of investors come, they sign a lot of MOUs. Now, one such MOU was signed with one steel company in Karnataka. Steel company in Karnataka way back in, 1990s. They said, you come and put up a steel plant, we will assign you a mining lease. Now, the steel company came, they put up a steel plant, but they never asked the government to assign them a mining lease. Then a lot of time passed, and then subsequently, somewhere in 2003, 2004, they asked the state government, the steel company asked the state government to assign them a lease out of turn. And the state government did consider. Then obviously matter was challenged. It went before from High Court, it went before the Supreme Court. The Honorable Supreme Court said, sorry, these kind of MOUs and all will not work. Whatever is there in the law, you have to follow the provisions of MMDR Act, nothing more and nothing less. So this is the primacy as far as MMDR Act is concerned. Now, the other issue that was before this 9-judge bench was, now list 2 entry 50. List 2 entry 50, it says taxes on mineral rights. It says taxes on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development. Certain words have underlined because all these words have been interpreted, all these phrases have been interpreted by the Honorable Supreme Court, which we will analyze everything going forward. Now, taxes on mineral rights, if at all any taxes to come on the mineral rights. Now, what is mineral rights? It's basically somebody getting a lease to work in a particular area to the exclusion of others. If I get a mineral right to work in a particular area, the other person, whoever, that means if I get a right, the other person will never get a right. It will never have any lease, will not get a right to work in that particular area. That means if I am given a lease, it is obviously to the exclusion of a third party. Nobody else will get a right until unless, of course, I can get out of it or I can transfer. That's possible. But taxes on the mineral rights, it is under entry 50 list 2. It is under entry 50 list 2. That means it is in the domain of the state governments. It is not with the central government. This taxes on mineral rights, you don't find the similar entry in the list 1 of, that means the union list, you don't find such an entry. This entry you find only in list 2. This was the whole matter of, this was the whole controversy. It went through various litigations and then finally the 9-judge bench has analyzed this. The 9-judge bench has analyzed entry 54 list 1, entry 23 list 2, and then entry 50 list 2. These are the few main entries the Honorable Supreme Court has analyzed and come up with the interpretation now. Now, before I go into the judgment part, now, first of all, the fundamental is the categorization of minerals. You must be reading in the newspapers, in the media, there's something called as major minerals and minor minerals. Now, what is the difference? Now, if you go to section 3, clause E, they have defined what is a minor mineral. It says building stone, gravel, ordinary clay, and any other mineral which the central government may by notification in the official gazette declare to be a minor mineral. Now, for example, we construct building, you take any material in the building, whether it is sand, whether it is stone, whether it is earth, everything is a mineral. But all of this, we call it as a minor minerals. Now, who decides a mineral to be a minor mineral? It is the central government always. Now, as on today, there are about 56, 57 minor minerals. That means only the central government has got powers to declare a mineral as a minor mineral. Everything else, we consider it as a major mineral. For example, iron ore, limestone, manganese, coal, they're all major minerals. Actually, in the MMDR Act, there is nothing called as a major mineral. Either it's a mineral or a minor mineral. That means any mineral that is not a minor mineral, it should be considered as a major mineral. So locally, we use the term major minerals. Otherwise, there's nothing in the law which says it's a major mineral. No, the law only defines a minor mineral. Now, in Bangalore and all, in Bangalore especially, where space constraints are there, we know there are a lot of high-rise buildings coming up. Now, obviously, we'll have basement 1, 2, 3, 4 and all. The basements will be as deep as maybe 50 feet, 80 feet and all. Now, obviously, when you're excavating in an area of maybe 5 acres or 10 acres, whatever few hundreds of apartments or flats that come up in a particular tower or in a particular project, now, when you excavate, obviously you are excavating minerals only. You excavate earth, sometimes you get soil, sand, sometimes you get stone. Now, if you practically see, all of these are minerals. Now, that excavation, is it mining? Yes, it is mining. But the point is, that is outside the purview of definition of a mine, because the intention when you build a building, when you come up with the project, is not winning of minerals. There, the intention is to come up with a high rise building, to come up with the apartments or the flats, so called. There, my intention is not to win the minerals. So, that is the reason there is an exemption. You don't have to take a lease. You don't have to take a permission from the government, whether central or the state government, to do the digging, even though it is akin to mining, that is an exempt activity. But yes, after you dig 50 feet or 80 feet from the earth and below, you would no doubt get minerals. If you are using it for your building projects, then nothing to be done. Let us say a builder, he wants to sell that mineral. Earth is a mineral, sand is a mineral, stone, what you get is a mineral. If he has to sell, theoretically, he has to pay the royalty, take permits, and then he's supposed to sell outsiders. Otherwise, he's not supposed to sell. If he's using it for his own project, then it's not required. So this is a little clarity I thought I will share with the members here, because in Bangalore, that is rampant, that is happening. And of course, wherever you're auditing, this could be an issue as far as compliance of laws are concerned. now, now, I've already told MMDR Act is by the central government. It is never by the state. In fact, in India, it is only MMDR Act. There is no similar act by any of the state legislation by virtue of powers given under NT 23 of List 2. No, it is only the MMDR Act. And of course, you have a host of rules. But MMDR Act, strangely, what they have done, if you go to section 15 of the MMDR Act, they have said as far as minor minerals are concerned, we don't come up with the rules. You come up with your own rules. They have said section 15, as far as minor minerals are concerned, they have delegated the position for coming up with the rules to the respective state governments. That means, as far as minor minerals are concerned, every state will have its own minor mineral concession rules. So basically, mining lease or the permissions you get from the government, we call it as a concession, because you get a leeway from the government. So that's how it is called as concession. And the word concession is defined in the MMDR Act. Now, the central government under the MMDR Act, section 15, they are saying, as far as minor minerals are concerned, we will not come up with the rules, but act will be the same. Act will still MMDR Act only. But as far as rules are concerned, we leave it to the state governments. You decide on the rules. Now, what the government has done, central government has done is they have made certain sections inapplicable to the minor minerals of the MMDR Act. And then under section 15, they are saying to the state governments, you come up with the concession rules, whether it is collection of royalty, whether it is period of lease, whether to whom it should be given, whether it should be given to an individual or a partnership firm or to a company, or what should be the background, what should be the rates of royalty, etc., etc. Everything you govern, we will not interfere. That is the reason we have MMDR Act and we have the rules framed by the central government for all major minerals, whereas for minor minerals, we have the MMDR Act, but the rules by the respective state governments. So this is another clarity I thought I will, because here and there you keep reading in the papers and the media that certain minor mineral concession rules have been amended, etc., etc. Now these are the mineral legislation again by the union. So you have the MMDR Act 1957. In fact, they did a major amendment in January 2015. They were just short of repealing the act. Everything they did, they amended the major provisions of the MMDR Act, and then the old rules were gone. They came up with all the new rules. 2016, all these rules are there. They came up with rules and they repealed certain rules also. Now, these are about 9 rules I've listed here. What is again relevant? Now, again, before I jump into the judgment, another very, very fundamental, I think this we should understand. Again, this is something got to do with the levies. I hope the tax professionals will understand what is a levy. Now, these are the host of levies. Now, these levies, I have bifurcated between major and minor minerals. Now, we have royalty and dead rent. Now, royalty and dead rent, they are there right from 1948, right from the time 1948 rules were introduced, 1948 Act and the rules were introduced. Initially, when we had this MMDR Act, MMRD Act 1948, the royalty was by way of rules, and then the lease agreements entered by the parties with the government. Whereas MMDR Act 1957, when it came into the picture after the constitution was enacted, they brought the levy in the act itself. That is where we have section 9. Now, section 9, we call it as a charging section in the MMDR Act. It is similar to section 9 of the CGST Act. Now, royalty, basically there are two varieties. Either it is fixed or it is ad valorem. Now, what is fixed and what is actually ad valorem? In certain minerals, they say you pay us fixed amount of royalty per metric ton of minerals removed from the lease area or minerals consumed within the lease area. It's something like, excise duty. We had excise duty earlier. The excise, the levy was on the manufacture, whereas we were paying excise duty only on removal. It could be immediately removal. It can be a month later or whenever. But the levy was already there on production. Whereas in case of royalty, they are saying you will pay the royalty the moment you take out the mineral out of your lease area, whether processed, unprocessed. Sometimes what happens, I do mining, I also consume within the lease area. Now you must be wondering how can somebody consume within the lease area? For example, there's a live case, ACC Limited, Wadi Cement Works, Gulbarga district. There they have the cement manufacturing within the lease area. Their area, the whole lease area granted by the government, state government, was around 471 hectares. So part of the area, they have put up a cement manufacturing unit. So both are within the lease area, mining as well as the cement manufacturing. So there what happens, they do mining and then the limestone that is produced is consumed by the cement unit inside the lease area. So the government says under the MMDR Act, section 9, you have to pay me the royalty. For limestone, they say fixed per ton, 80 or 90 rupees, depending on the grade. Ad valorem is something like a percentage on the sales price, a percentage of the sales price. Now, section 9, I pay royalty. The charging section is section 9 of the MMDR Act, but I refer to second schedule of the MMDR Act, wherein There are rates of royalty listed in the second schedule. That means section 9 read with the second schedule of the MMDR Act, you have to defray the royalty. You have to defray the royalty. Now, because of illegal mining, because mining is known for all illegal happenings, the government does not have faith on the miners. They disregard the sale value that we disclose, we as miners disclose in our tax invoices. We disregard, the government disregards that value. The government every month, they come up with average sales price. Suppose, let us say, you take a mineral iron ore. I am actually selling iron ore at say 2000 rupees per ton. Whereas the government may come up with the average sales price of around 2100, or it could be 1800, 1900. So this is how it is, because they are saying lot of cash sales, lot of underbilling. So in the past, all these things have happened. So that's the reason now what the government is doing is every month they come up with something with a parameter called average sales price of various minerals. Wherever it is linked to ad valorem, like iron ore, it is 15% of the average sales price. Manganese 5% of the average sales price. So basing on that price, not on my sale price that I show in the tax invoice, on the sales price declared by the government, I pay the royalty. Now, what is this dead rent? Dead rent is nothing but minimum guaranteed royalty. In a particular year, you may not do any production. After you commence the operations, you may not do any production, because initially, if it's a virgin area, you have to do a lot of development work. You may not get mineral initially. 1 year, sometimes 2 years also, I may not get mineral. Possible. Then the government says you have to pay minimum dead rent. Now, dead rent is valued on the extent. That means some amount, so many rupees per hectare of the area granted to you as a lease. That means the government says if you operate, very good. If you don't operate, you have to pay me on the basis of the extent. Now, generally, first year of operation, they say you don't have to pay dead rent. Dead rent comes in from second year of operations, second financial year. Let's say I've got a lease in month of February of a particular financial year, then the first year is only 2 months, February and March. The second year will be the full financial year. Now the government says you pay royalty or dead rent, whichever is higher. So that means dead rent is nothing but minimum guaranteed royalty. Now for time immemorial, we had only royalty and dead rent till about 2015, January 2015. In January 2015, central government introduced something called as DMF, contribution to DMF. It is percentage of royalty, section 9 capital B. This was never there before 2015. DMF is contribution to district mineral foundation. Every district where the mines are operated, they will have a trust. It is called as the respective state district mineral foundation. Similarly, they came up with something called as NMET, National Mineral Exploration Trust. This trust is managed by the central government. This trust is managed by the central government. Here they say you have to pay 2% of the royalty. This came only in 2015. It was never there before. Again, this is another levy which is mandatory in nature. Auction premium. You will be wondering, as far as mines are concerned, there was no auction prior to January 2015. Mines were never ever auctioned. As far as major minerals are concerned, the lease areas were never ever auctioned. Auction started by virtue of the judgment of the Honorable Supreme Court in the coal matters, wherein they cancelled many coal mining areas, and then they said no, you please auction it, and of course auction they're following because of the telecom, auction, spectrum auction, blah blah blah. So they have introduced now then we have something called as additional consideration, fifth schedule. This has come in March 2021, and we have another additional consideration in March 2021. Now additional consideration, fifth schedule, additional consideration, sixth schedule. Now what happens? Now, because of the amendments, to private party major minerals, the government says you work only maximum 50 years and then you surrender and go home. There are no renewals to private parties. Whereas if you are a government entity, PSU, or a corporation of a government, then they are saying we will allow you extensions for 2020. That means initially 50 years and then 20 years I will extend, another 20 years I extend. But the government says if I'm extending to a PSU, a government company, then you have to pay me some additional consideration that is linked to the royalty. That is this fifth schedule additional consideration. Similarly, sixth schedule additional consideration is there are some mining areas wherein after you mine, you have to 100% consume within your own industry. Like ACC Limited, Wadi, there, that's a captive mine. Mandatorily, whatever is the mine, the material that is produced, they have to consume within their own industry. But the issue was what happens in a particular year if I'm not able to consume? I may consume, little less. Then what happens? Then there was a risk of determination of the lease area. Now the government says up to 50%, we will give you relaxation. But again, you have to pay me some additional consideration. So these are the levies. I have bifurcated what is applicable to major and what is applicable to minor. I did spend some time because this all critical to know the judgment in a better manner. So these are the different levies. I am not saying these are taxes. I am not saying these are exaction or impost. These are mineral levies. These are all coming by virtue of the MMDR Act or sometimes the rules. If it's a minor mineral, it comes in the rules also. Now, the other thing the Honorable Court was seized of was whether this levies can it be considered as a statutory impost as defined in clause 28 of Article 366. It defines taxation includes imposition of any tax or impost, whether general or local or special, and tax shall be considered accordingly. Now, the matter before the Honorable Supreme Court was whether this royalty is akin to statutory impost or an exaction, because since it is compulsory in nature, giving royalty is not optional, it is mandatory. Now, since it is mandatory and since it is coming by way of an enactment, MMDR Act, whether it can be considered as akin to a statutory impost was another issue that was before the Honorable Supreme Court. Now, this is the background. Now, I think I will pause now. Now, these are some of the fundamentals. And of course, I've already discussed Inter 54 list 1, Inter 23 list 2, and Inter 50 list 2. At this juncture, if anybody has got any queries, I am open to clarify so that before I proceed further, before I jump into the judgment, the 9-judge bench judgment, I thought I have to lay down some basics, which is what I've done for last 30 minutes. Anything anybody wants to know, any clarity at this level?
Sir,
Before I
you
move
said
forward?
it is a levy, not a tax. So
Yes.
could you
Yes.
just tell how does it differ? It's a levy, but not a tax.
We will come into it. That is the main crux of this judgment. We will come to it.
Fine.
Yes. Anything else on the fundamentals? Because it's a mineral law. Of course, I don't know how many of you have dealt. Probably, I think Jatin sir must have covered in the book that he has published. But sir, I'm sorry, I've not gone through the book of yours, sir. I have purchased though, but I have to look into it because yeah, I think you have a chapter on the MMDR Act as well. I understand.
Right. In this one, there are some number of judgments that have been surveyed. Many judgments are from SR Burmai to Kerala. Things have been addressed in this touched upon in this judgment. If we can also get some.
Sir, your voice is breaking.
Which
Sir, I'm sorry, your voice is breaking.
Is it better?
Sir, please, sir.
So I want to request if
Sir, no,
considering that
sir.
there's so many judgments.
Sir, not audible, sir. It is breaking.
Okay. Are you here now?
Yes, sir.
Asking if, since there are so many judgments which are referred in this decision, if it is possible for us to have a list of which are the judgments that are overruled, which are the judgments that have been upheld, it will help.
Yes, sir. Yes, sir.
Okay.
I'm going to discuss that also. In fact, one SR Bomai's case also is there as part of my PPT. They have
Okay.
analyzed hundreds of judgments, sir. In fact, I was shocked to read through this whole judgment. In fact, I had to read it. I have to read it twice because once I had to address some minor audits, and now for this August gathering. So they have analyzed hundreds of judgments, and amazing, amazing way they have come up with. Of course, they've demolished a lot of interpretations, lot of legal jurisprudence. But yes, it's the law of the land today. We are going to touch base, sir, and yes, towards the end, I'm also going to say what are the judgments this 9-judge bench has overruled. That is also covered, sir. Here and there, I'll be touching about a lot of judgments, and then at the end, we will also see what are the judgments this 9-judge bench has overruled. Yes, sir, it is there. It's part of the presentation. Anybody else? The fundamentals before I get into the judgment part.
Sir, MDR, what is the constitution of MDF and how it is dealt?
MMDR Act, right?
No, District Mineral Fund.
Okay, DMF, correct. Now, DMF, actually, there are separate rules. Basically, DMF, what happens is every district, this is basically, this all has happened after the intervention of the Honorable Supreme Court because there was rapacous mining, illegal mining. And there's plundering of the mineral resources in a lot of districts, whether it is Karnataka, Orissa, or wherever minerals are found. Massive illegal mining and a lot of forest areas were looted. And of course, the money was made only by the mine owners because there's a huge demand for certain minerals. So monies were made only by the certain mine owners and certain people involved in the trade. Then the Honorable Supreme Court said, no, sorry, like in Karnataka and all, they formed something called as SPV, special purpose vehicle, so something called as KMARC, Karnataka Mineral Environment Restoration Company. And then they said, whatever material you are selling, some percentage of it will go to this SPV, and this SPV will get involved in rehabilitations of the mining affected areas in a particular district. Especially in Karnataka, they said 3 districts, Ballari, then Chitradurga and Tumkur. The Honorable Supreme Court said, taking a cue from the Honorable Supreme Court judgments, the MMDR Act was amended in 2015. The MMDR Act, they introduced 9B. They said, we will also establish the District Mineral Foundation in all the mining affected districts. That means every district where mines are being operated, you will have something called as DMF, District Mineral Foundation. And then every person operating a mineral, whether it is major or minor, he has to contribute certain percentage of royalty, 10 or 30, depending on the case, whether auction case or a non-auction case, you have to contribute 10 or 30% of the royalty to this fund. It is collected by the Directorate of Mines and Geology, but the amount doesn't go to the treasury of the state. It doesn't go to the treasury of the state. It has to essentially go to the District Mineral Foundation. And what will happen with these funds? Basically, they have to do upliftment of the society. They have to construct schools, they have to construct roads, railway lines, infrastructures, community halls, all these things they have to do. But we have seen a lot of misuse also being happening. So this is the whole concept of DMF. It is mandatory. This is another levy by the MMDR Act, and of course, even on the minor mineral, the state governments are empowered to levy. Section 15, capital A, gives powers to the state government to levy DMF even on the minor minerals. I hope I've given you the whole explanation of DMF. Yeah, the constitution you asked Mr. Mailar, it's basically headed by the district in charge minister. All cabinet state, it is headed by the district in charge ministers, and then you will have the DC, you will have the directorate Directorate of Mines and Geology as a member secretary, the local office, and then you will have people drawn from the revenue department, and there are rules how the DMF has to be formed. It's all there, and there is one model deed also, and these all have to be registered. So it's something like government trust, you can call it, something like that. So that's how the whole DMF operates. So similarly, we have something called as NMET, but NMET is by the central government. That is a trust. NMET is National Mineral Exploration Trust. We pay mandatorily 2% of royalty. Now, this NMET is applicable only to major minerals and not to minor minerals. Now, because they don't have powers, they have said NMET can't be applied for. That power is not being given to the state governments to levy on the minor minerals. Now, NMET, what happens is by the name National Mineral Exploration Trust, because India is far behind as far as exploration is concerned, because all minerals are deep seated, whether they are within the surface, they're below the surface. So you have to do a lot of exploration. We are lacking. It's something like R&D. In other industries, we have something called as R&D. So here, our R&D in mining industry is nothing but exploration. Now, to do exploration, you need money. And we are lagging behind, and definitely government is not doing anything in exploration. So that's the reason the central government has come up with the trust. Again, there's a body headed by the ministry people and all. And of course, there are experts drawn from various fields. The 2% amount, whatever you do, it goes to the trust, and this fund is used only to carry out exploration activities. Of late, you must have heard about critical minerals. Now, sometime back, we were discussing about batteries, electric vehicles, batteries. The major mineral to manufacture battery is lithium. Now, lithium is not available in India because it is yet to be explored. Commercial scale, it's not available in India. We are importing lithium. There is import dependence. Now, since there is push on the EV vehicles, now where is the battery? EV means battery. To manufacture battery, you need lithium. Where is lithium in India? Now, that's the reason they are exploring. They are saying in J&K, there are some deposits. No. Now, for all this exploration activity, they will dip into this funds of NMET and the government will spend. So this is the background about NMET. Again, it was brought only in 2015. It was never there before. So this is how we are heading. All right. I think that should be good enough. So moving on, now I will come to the judgment per se. So these are certain basics. And Deepak sir, your query, levy and tax will be answered definitely. Or in the succeeding slides, we will touch base on it also. Yes, Mylar sir, I think you can see my screen, right? Because I've started sharing again.
Yes, sir. Yes, sir.
Yeah. Now the judgment, Honorable Supreme Court judgment. This is basically in the court, it is referred to as Civil Appeals number 4056 of 1999. From 1999, the matter was lingering. Only now, 2024, we have this 9-judge bench order. Now, the parties are basically Mineral Area Development Authority, MADA we call in short. This is basically a local authority in the state of Bihar. This was the matter. It was against Steel Authority of India Limited. Now you can see Steel Authority is a respondent here. MADA is an appellant. MADA is an appellant, Steel Authority. Now, along with Steel Authority, there are a lot of private people who got involved, private operators. Now, if you see, Steel Authority is a respondent before the Honorable Supreme Court. That means Steel Authority will be a petitioner in the before the Honorable High Court, wherever it is litigated, because the matter was won by by Steel Authority of India as a petitioner before the Honorable High Court. Now, obviously, the aggrieved party, Mineral Area Development Authority, is before the Honorable Supreme Court. So that's how the MADA is an appellant and SAIL is the respondent here. Along with SAIL, there are a lot of parties who got involved. There are judgments rendered on 2 dates. One is on 25th of July, the other one is on 14th of August, all in this year 2024. There are about 80 parties involved in this judgment across the country, especially wherever there are mineral bearing areas, whether it is Orissa, Chhattisgarh, Madhya Pradesh, Andhra, Karnataka, Tamil Nadu, all there are about 80 parties before the Honorable Supreme Court. And definitely all private parties, all private parties will be, definitely they are like respondents. And most of them, they were hit by the rulings of the Honorable High Court at the local level. And that's how they were before the Honorable Supreme Court. Now, this is the 9th bench. The ruling was in the ratio of 8:1. Ruling was in the ratio of 8:1, mind you. And of course, the majority, it was authored by the Chief Justice, the current Chief Justice, 8:1. Only one dissenting judge, and the judge is Madam, Justice Nagaratna. She was a judge of the Honorable High Court here in Karnataka. Now she has been elevated. Of course, now she is before the Honorable Supreme Court. In fact, I had one occasion to attend her proceedings here before the Honorable High Court in one of the mining matters. It's a 393-page judgment. It's a 393-page judgment. Since there are, the ruling is in the ratio of 8:1, they have given both the judgments. It is running in 200 pages and 193 pages. So you will have both for and against rulings given. So to understand, you have to read all the 393 pages. Otherwise, it is difficult for you to make head and tail of this judgment. So this is the background. So this is the whole stuff that is involved. Now, this is the 9-judge bench, obviously. Now, what is the genesis? What is the genesis of this MADA case? We have to go back to one India Cements case. The whole thing started somewhere in the 1960s. The litigation, the list, what we call, it started in the 1960s. Now, what happened was, state of Tamil Nadu, they had something called as the Madras Panchayats Act 1958. Of course, wherever Madras is there, subsequently the name has been changed to Tamil Nadu. Sometimes, it is referred to as Tamil Nadu Panchayats Act. Now, what happens under section 115 and section 116? Under section 115, they wanted to levy a cess at the rate of 45 paise per rupee of land revenue. The local law, that means the state act, under section 115, they wanted to levy a cess at the rate of 45 paise per rupee of land revenue. But what they did was, somewhere in 1964, they introduced an explanation to both sections 115 and section 116. Now, section 116 wanted to levy surcharge on cess. Cess in 115, surcharge on cess was in 116. Now, the surcharge was to go to the local panchayat, whereas cess was to go to the state government. That was how the law was to be enacted. By the amendment, what they did was, in 1964, they amended with retrospective date. They said, land revenue in case of mineral bearing land will include royalty also. They inserted an explanation saying that land revenue includes, in case of a mineral bearing land, it includes the royalty payments made by the lease operators to the government. So technically, it is cess on royalty. That is how the whole thing was structured. It says, land revenue, whatever the way the laws have been defined, to come up with the measure of land revenue. They also say you include royalty also if it's a mineral bearing land. And again, in 1964, they got in an amendment. They said with retrospective date. That means it is from 1961. This Madras Panchayat Act 1958, I think, was implemented from 1961. So obviously, after the amendment, there was a notice served by the district collector on India Cements, because India Cements was operating certain limestone mines. Of course, we all know India Cements also has cement manufacturing units. Now, recently, I think 2 months back, UltraTech is trying to take over India Cements. Going forward, you may not have the name of India Cements. It will be probably converted into UltraTech Cements going forward. Already the acquisition has happened. They are in the finalizing formalities. Now, this matter was litigated. The list started here, 1964. Now, what the company did was, it filed a petition. I've given the petition number before the Honorable High Court of Madras, single judge. The order was passed on 23rd February 1967. They said, they upheld the levy. They said, no, the state government can levy cess on royalty. There's nothing wrong. It's like royalty is like a measure. It's a measure of land revenue. It's allowed. It's allowed. That's what the single judge bench ruled. That means the judgment was against the company. Obviously, the matter landed up before the division bench, single judge to division bench. Again, the division bench upheld the order, single judge order. The order was dated 13th of October 1969. See, from 67 to 69. And then, obviously, here also the company lost. the division bench upheld the single judge bench order. So obviously the matter reached the Honorable Supreme Court. The civil appeal number is 62N of 1970. So they filed on SLP in the year 1970. Now, what did the high courts do? Both single judge and the division bench, they looked into entry 49 list 2. They looked into entry 49 list 2. They said taxes on lands and buildings, it is under list 2. That means the state government is well within its rights to come up with any tax. Cess is also akin to a tax. Of course, we all know cess or surcharge is also akin to tax only. And they said lands includes mineral bearing lands also. So there's no bar. So they said by looking into entry 49 list 2, both the single judge as well as the division bench, they said the states can levy. They upheld the levy. They said no, state government is well within its rights. So this is the whole genesis. This is the whole genesis. Now what happens? See, we saw entry 54 list 1. It is on regulation of mines and mineral development. Entry 23, again, regulation of mines and mineral development, but subject to entry 54 list 1. To the extent the powers are already usurped by the central government, the state cannot. Whereas entry 50 list 2 talks about taxes on mineral rights. See, taxes on mineral rights is different from taxes on lands and buildings. Entry 49, that means there are 3 entries in list 3, list 2. There are 3 entries in list 2. Entry 23, list 2, entry 50, list 2, and entry 49, list 2. Now, all of these are now before the Honorable Supreme Court to interpret. Now, they said, yes, lands includes mineral bearing land. Obviously, the levy is valid. Now, the Honorable Supreme Court then, basically, the matter was referred to the Constitutional Bench, basically 7-judge bench. They said MMDR Act is a comprehensive code for regulation of mines and development of minerals. And Section 9, provides the holder of mining lease to pay the royalty, and rates are also specified. And then they said royalty is a tax. The court also held that royalty cannot be used by state as a measure of tax on mineral bearing land because it is outside the purview of entry 49 because it is already covered by entry 54. Here it clearly said, 7-judge bench, the date of the order is October 1989. SLP was filed in 1970, whereas the judgment was in October 1989. Here it clearly said the state legislature is not competent to impose cess or tax on royalty. The court invalidated the cess on the land levied with reference to value of minerals. The court observed that royalty is a tax. The court said royalty is a tax, and by virtue of entry 54, it's already taken over by the central government. So you can't levy. That is how it is. And they said with respect to entry 49, they said royalty is directly relatable to minerals extracted and therefore would only be relatable to entry 23 and 50 of list 2 and not entry 49 of list 2. If at all the states want to tax, they can go under entry 50. They can go on entry 50, but definitely not under entry 49 because the High Court decisions were based on entry 49, which the Honorable Supreme Court 7-judge bench negated. The 7-judge bench clearly said royalty is a tax. They said royalty is a tax. So obviously there can't be tax on tax. So cess being another tax, so it can't be there. So it is tax on tax. Cess on royalty will be akin to tax on tax. So that's the reason they said, sorry, you cannot levy. Then what happened? Subsequent to India Cements, that was in 1989, there was another judgment again followed by Orissa Cement. It was in April 1991, again by the Honorable Supreme Court. They followed the dictum, of the 7-judge bench, and they said sorry. Even in Orissa, there was some cess. They had a levy against it. They said sorry, you cannot. Now what happened? We should understand the implications. October 1989, the 7-judge bench in India Cement ruled royalty is a tax. So that means there can't be any cess or any surcharge, or rather any levy involving royalty on a mineral bearing land. That was the judgment, and of course, it was a 7-judge bench. So, obviously, every high court, either before the judgment or later on, they started squashing the state enactments. They started squashing the state enactments. I have listed 11 enactments here. So, by virtue of the India Cement's judgment in the Supreme Court, all these 11 enactments were held to be null and void. You had one enactment in Andhra, and of course, state of Bihar. We also had in Karnataka 2 enactments, Jilla Parishad, and then we have Karnataka Mineral. All of them were squashed. In fact, this Karnataka Jilla Parishad, the matter was squashed here only by the Honorable High Court of Karnataka, Madhya Pradesh, Maharashtra, Orissa, Tamil Nadu Panchayat. That was the main issue before the Honorable Supreme Court 7-judge bench. So now, all of these enactments were squashed. Now the problem is, by virtue of these enactments, lot of state governments have collected the levies. In the name of cess or surcharge, they have collected the levies. Now the question is, what will happen? Because the 7-judge bench, so India Cement said, all the cesses are wrong, they're null and void. So technically, all the state governments, they have no choice but to refund the cesses or the surcharges that were levied by virtue of all these 11 enactments. So obviously it was a very difficult situation. Then circa what the government did, the central government, they did some magic now. They did some magic in 1992. In fact, even I was not aware, even though I'm practicing this mineral laws for about 25, 30 years. But now after reading this judgment, I have come up with something called as a Validation Act. I've come across something called as a Validation Act. The government, the central government did some magic. The government said, all right, by virtue of the India Cement judgment, these 11 enactments are gone, but you have collected the levies, whatever right or wrong. Some states have collected in certain cases. There was some stay granted in certain cases. The levy itself was struck down. There were various permutations and combinations. So the central government said, all right, don't worry, I will step in now. So they came up with an enactment called the Validation Act. Initially, what the government did was, central government, they came up with an ordinance. This ordinance was in February 1992. Again, where is the power to the central government? They said, by virtue of Entry 54, List 2, because regulation of mine and mineral development, which includes the mineral levies. So I will indirectly get powers under 54, and that was the ruling in India Cements. So I have the power. They came up with this ordinance, first of all, and obviously ordinance became a law on 4th of April, 1992. Now, if you examine this act, this Validation Act of 1992, there are just 3 sections in this act, nothing else. There are just 3 sections and 1 schedule, nothing more. Now, what was the preamble? The central government said, it is an act to validate the imposition and collection of cesses and other taxes on minerals under certain state laws. It said to validate the imposition and collection of cesses and certain other taxes on minerals under certain state laws. Of course, the short title and all is there. It extends to the whole of India. Now, it says it shall be deemed to come into effect from 15th the day of February 1992, because there is an ordinance in February 1992. It was passed in the parliament on 4th of April 1992. Now, section 2 is a critical section here. Now, of course, this was an enactment for a very limited period. It says section 2, validation of certain state laws and actions taken and things done thereunder. Subsection 1, they say, the law specified in the schedule to this act shall be deemed always to have been valid, as if the provisions contained therein relating to the cesses of the taxes and minerals had been enacted by the parliament, and such provisions shall be deemed to have been remained in force up to 4th day of April 1991. I think we'll have to spend some time on this. There are 2-3 things we have to understand here. First of all, they are saying the law specified in the schedule. Now, what are the laws specified in the schedule? If you go to the schedule, there are those 11 enactments which were struck down. There are those 11 enactments which we saw a little while ago. Now, what the government did was, actually those 11 enactments, the state enactments, they were never by the central government. But what the central government did was, those 11 enactments they brought in the schedule, and they said, even though they are by the state, now you deem as if we have enacted, the central government has enacted by virtue of this validation act. That's the reason they brought in this deeming fiction. And mind you, this validation act has come into force with effect from February 1992. But they say it's these enactments, 11 enactments, shall be deemed to have been remain in force up to 4th day of April 1991. That means the law is forward looking. The law is from 1992, April 1992. But they are saying, I will validate the impost, I will validate the cess that was levied up to 4th day of April 1991. It's very, very, I mean, I don't know. This is the first time I've come up with an enactment that, a date comes much later, whereas the validation happens much before. That means for all the levies up to 4th day of April 1991, 1992 enactment is giving effect to, is giving life. So subsection 2, it also says, notwithstanding anything contained, okay, in this validation act, no refund, no suit, nothing can be filed, so that the state governments will not have to refund any of the cesses collected earlier, because all these things is the subsequent development. Subsequent to the India Cements order that was in 1989 and followed by the Orissa Cements. So that is the reason. Now, the other thing we should understand is what is the relevance of this 4th day of April 1991. I just now mentioned Orissa Cement order again by the Honorable Supreme Court. That was the judgment delivered on 4th day of April 1991. That was one of the last judgments delivered. By that time, a lot of high courts or the Supreme Court had invalidated all the local cesses. So the last of the judgments delivered was on 4th of April 1991. Following the India Cement judgment, that was in Orissa Cement's case. That is the reason the Validation Act says the levies up to 4th day of April 1991. But of course, following, because the law also has to be just and equitable, they said, in case if any entity has paid any excess amount of cess, then they have right to refund. Only that much has been preserved. That means this is section 2. And section 3 is all about repealing the ordinance. That is all, nothing else. Repealing the ordinance and giving effect to the act. There are only 3 sections. Section 2 is important, and the schedule. Now, these are the schedule. Again, the same 11 enactment, they brought it in the schedule. Now, what happens? Obviously, in India, any act is obviously litigated. Even this act was litigated, no doubt. In one of the cases, the Honorable Supreme Court again looked into Validation Act. The matter traveled from the High Court. I will tell you which High Court, I will tell you which is the party. The matter went before the Supreme Court. The Supreme Court, Honorable Court, it was a two-judge bench. It analyzed the Validation Act. The Supreme Court said the Parliament basically, has adopted the route of legislation by incorporation. If you see the Validation Act, what it has done, the Validation Act didn't want the states to give any refund. See, this refunds and all we find only in taxes, income tax or probably the indirect taxes, whether it is the earlier VAT or sales tax or entry tax or professional tax, whatever. That means only direct and indirect taxes. In none of the other, at least in mining laws, as I've seen, there's no question of refund. Once money given, gone case. So obviously, but because of the striking down of those cesses by the state enactments, so the states had to refund huge sums of money, hundreds of crores. Now, obviously, there was a difficulty. So that is how this Validation Act has come. Now, what the central government has done, they have followed this route of legislation by incorporation. They said, even though the enactments are by the state, you deem as if we have enacted by virtue of powers conferred under Inter 54 of this one. So that's how they've coined this word, legislation by incorporation. They also talked about archival drafting because the laws were already there. So you only archive, you take out and then you from the archivals, you take out and come up with an enactment. And it also talked about referential legislation because there is a reference to the state enactments, even though it's a central enactment, a Validation Act, but there's a reference to the state enactments. So they said, yes, it is okay, it is still valid. And what is the objective of this Validation Act? It is basically not to allow these taxes, to refund of taxes, nothing else. It's just not to allow refund of the cesses imposed by the respective state governments. The case that I was talking about was P. Kirnadasan and others was the state of Tamil Nadu. It was ruled by the two-judge bench in 1996. Okay, this is a citation. The date of judgment was 26th of July 1996. Here it upheld the levy. It said the levy, I'm sorry, it upheld the Validation Act. The Supreme Court said it's okay, nothing wrong in it. The central government is well within its power. Enter 54. Yes, it can come up with a Validation Act. And of course, it's the prerogative of the central government. If they want to incorporate certain state laws and it wants to deem it as if it's a law enacted by the central government, so be it. So we will not interfere. The act is okay. Actually, it traveled from the Madras High Court to the Supreme Court. Madras High Court also said it is okay. Obviously, the party did not agree. P. Kannadasan, he was a mine operator, obviously. And of course, there are so many other parties involved. The matter was before the Honorable Supreme Court. The Honorable Supreme Court upheld. But now it was a two-judge bench. But the issue here was, they said, any levy under the state enactment, levy I mean the cesses or the surcharges, up to 4th of April 1991, mind you, up to 4th of April 1991 was the subject matter of the Validation Act. The states are well within their right to collect levies, if not collected, up to 4th of April 1991. But nothing after 4th of April 1991. That means from 5th of April 1991, the states cannot collect. Because 4th of April 1991 is nothing but on the day, the last judgment by the Honorable Supreme Court in the Orissa matter. That's the reason, the date. Now the issue was, that has been upheld. The levy is also okay. Obviously, no refunds granted. But there's an issue. The issue was, the Honorable Supreme Court, two-judge bench, they said up to 4th of April 1991, the states can collect. If at all they have not collected any cesses, they can still collect. This was again litigated. It was litigated by TISCO, Tata Iron and Steel, those days. Of course, today it is called Tata Steel Limited. Earlier, the old name was Tata Iron and Steel. Again, in the state of Bihar, it was again litigated. So this is the citation. This is the citation. Now, what happened? The district mining officer, it's a case of district mining officer who was a Tata Iron and Steel. Here, what had happened was, since there was a stay granted earlier, the company said, no doubt the Validation Act is okay. But if at all, by virtue of the stay, if there is cess that is not collected prior to April 1991, then sorry, you cannot collect it now. The Tata Iron Steel TISCO, it took a stand, it falls foul of Article 265. It said it falls foul of Article 265. So obviously the matter was litigated from the Patna High Court, Honorable Patna High Court, the matter reached before the Supreme Court. Now here the CJ, he referred to a three-judge bench because already the matter was decided by two-judge bench. The matter was referred before the three-judge bench. The three-judge bench said, look, first of all, the levy was not right, but the last judgment was 4th of April 1991. By virtue of any state, if the states, by virtue of any stay granted by any honorable constitutional court, whether it is High Court or the Supreme Court, if there is a stay and the state governments were not in a position to collect the levies, the cess or surcharge up to 4th of April 1991, the court said, sorry, you cannot collect it now. The court said, sorry, you cannot collect it now. The court said, what was the intention of this Validation Act 1992? The intention was to not allow state governments to refund them, if at all they have collected. If they have not collected, then they can't collect it now in the garb of Validation Act 1992. That was the whole judgment. That was the whole judgment. So that is how it has to be read. That means the three-judge bench upheld. They looked into Article 265 because Article 2, we all know, taxes and the collections have to be levied and collected only by authority of law. Technically, the state governments never had any authority of law to come up with a legislation to levy cess. So obviously, you can't even collect. If at all you have not collected prior to 4th of April 1991, then sorry, you cannot collect it now. That is the sum and substance. So this is how the litigation proceeded. Now, in this whole litigation, obviously even India Cements was one of the parties to this Validation Act. Even India Cements was one of the parties to the Validation Act. See, those days, 1960s and 1970s, cement was a controlled commodity. In fact, somebody wanting to manufacture and sell cement, they need some license from the governments. You know, it was a license Raj. So cement was one of the commodities, you know, wherein they had to have a license. So the moment 1961, we have already seen Tamil Nadu Panchayat Act or the Madras Panchayat, when there was a levy, 45 paisa per rupee was there. The company litigated, it was before the Honorable High Court of Madras, wherein the Madras High Court, Honorable Madras High Court, granted a stay. That means the stay was operating right from 1961 and the stay continued up to 1989. The stay continued up to 1989 till the 7-judge bench decided the matter, wherein they said royalty was a tax. So obviously, cess on royalty being a tax on tax cannot be there. So that means I can say it is a benefit of litigation to India Cements. So India Cements never paid even a single rupee of cess right from 1961. It was all along litigating. That means it saved crores of rupees. Now, because of the judgment in Tata Iron and Steel, the benefit was given to India Cements. So that means because of the judgment, 3-judge bench of the Honorable Supreme Court in Tisco matter, even the India Cement will not pay any cess. So that is the whole thing. So basically, they looked into the intention of the lawmaker, and this is all the ruling. So before I go, this was all about India Cements. This is only part of the discussions. And then I have to now move into, that was one track. Now I have to move to another track. That means I need to essentially come to another list in the case of Kesoram Industries. Now I want to pause here for some time. So now I have covered the basics. I have covered India Cements ruling completely. How the matter traveled from the High Court to Supreme Court, various other matters, various other state enactments, and then finally the Validation Act, and what benefit India Cements got. Now, at this stage, if there is any query, I would like to take it up because before I move into the next track, that is the Kesoram matter. I thought I'll sip a cup of coffee also, little bit. Yeah, any queries? I'm open. We can discuss at this stage because this is not like a tax GST matter or any tax what we normally discuss. Little different, little intense. So anybody wanting to know anything, any discussions at this stage, you're welcome.
So do you have the India Cement judgment? Jatin was saying para 34.
Yes, it is there. I will cover that now. In case of Ram, I'm going to cover that para 34.
Okay.
Anything on the Validation Act? It was very new for me. I never knew technically. Only after going through this judgment, I came to know that the central government can do something like this. So you can see how the legal jurisprudence is evolved, right from 1960s, till about maybe late 1990s, how the legal jurisprudence is evolved. So India Cements was the law till Kesoram matter was before the Honorable Supreme Court. India Cements was the law. That means it was all along considered royalty was a tax. So anything on royalty, cess also is akin to tax. So anything that means cess on royalty is nothing but tax on tax. And that was a stand taken by various high courts across the country. I hope, I'm in a position to convey what I want to convey because this is a different gathering. It's not, I'm not addressing certain mining professionals here. So the act could be a little alien, but I'm trying to, do it in such a manner that we all understand. so that we learn something out of it. If not on the mineral laws, at least you will be very confident on how the entries to be interpreted. Once I complete the discussion, you will know how the entries in list 1 or list 2 should be interpreted. And what are the powers given to the state and the union. So that much definitely, that learning we will have.
Good going, sir. The only thing is, as far as my knowledge goes, the validation acts are generally enacted to rectify certain inadvertent errors committed by the legislature and not to undo or stop something which was envisaged at the beginning. So this validation act, as you explained, was to restrict refunds in case they are due, which was not contemplated by the law when the law was state laws, respective state laws were enacted at the beginning. That is where I was just I don't know what basis this validation act was upheld by the Supreme Court. What was the reasoning behind where upholding that law?
Basically, it was in the interest of economic development only, because imagine 11 enactments, roughly I think 6 or 7 states, all the mineral bearing states, Madhya Pradesh, Karnataka, Andhra, Maharashtra, Chhattisgarh. Just imagine, because these cesses were there from 60s and 70s. And now 1989 or 1991, the Honorable Supreme Court says, sorry, these enactments are void. So obviously, you are falling foul of Article 265. So obviously, to refund. Now, but taxes are already paid. The another thing the Honorable Supreme Court looked into was many of the players, whoever has paid cess, he would have passed on, the cost to the customers, right? Nobody would have paid from the pocket. Assuming cess has been paid by a leaseholder, he would have obviously recovered that cess. So that means already there's nothing like unjust enrichment here. He has already passed it on. The cost has already been passed on. So there will be nothing, no loss to the operators. Whoever has paid also, there will be nothing wrong. But if the states were to refund, there will be huge impact on the economy. So citing these principles, they upheld this Validation Act. And it's very strange. The 1992 Act is promulgated and rectifying the errors, not allowing refunds up to April 1991. This is little strange. So that's how it is. So that's the law, because it was already decreed decided by the Honorable Supreme Court.
Right, sir.
Yeah. Anything else? Anybody? I think, Madam Ashika, you have something to ask, because Venu sir was telling me that you were supposed to deal on this topic, but somehow it got shifted to me. So since I deal in some of the mining matters, so anything, madam, if you have gone through the judgment at all, and then you have anything to add to what I've discussed so far, you're most welcome, or anybody else for that matter.
Sir, the way they distinguish about the entries, constitutional entries, in there they talk about list 1, entry 23, 49, where they distinguish how that to be read, that I felt that in that I need more insight how it should be, because they distinguish the word tax should not be read in that regulation part. And
Yes, madam. Yes, madam. Yeah.
so I was thinking what else can be covered over there, because like once I discussed with Rajesh sir also, so he said me about 7th schedule. He said service tax has been introduced through 7th schedule. So there will be a impact of that also. So I was about to analyze, but I didn't went so much.
Okay, madam. All this we are going to discuss, because it's a very elaborate presentation. The interpretation of the entries will come little later after I discuss Kesaram, because I'm still in the origin, the genesis of this MADA matter, how this whole thing came about. So we have discussed only one part, that is India Cements. And now we come to Kesoram, and then we'll get into the actual judgment, rendered in the MADA matter. We will look into all that. Of course, now I see some queries here. Sujata madam is asking how much is the government fee, royalty, rent as a percentage cost of mineral. Madam, I have one slide for this. I will share this with you. Complete levies, I will tell you. Then, of course, Jatin sir is asking, para 34. Yes, sir, it is there now. It's coming in my slide. Because para 34, I have reserved it for Kesoram discussion. So, which we are going to see it now, sir. All right, I will again restart sharing my screen.
Vijay sir,
Yes, ma'am.
very basic question. We are discussing on this entry 49 and as well as we are discussing on entry 50 also. And both are at the state list. So why we have to, is it something overlapping between entry 49 and entry 50 of list 2, sir?
Madam, since you asked, of course, it's there in part of my discussion subsequently.
Okay,
They have
then I think we
clearly
can
said,
discuss that. Yeah,
they
we
have
can
said,
discuss. Yeah.
no, they have said entry 49 and entry 50, there are two distinct entries. Now, entry 50 talks about taxing on mineral rights, whereas entry 49 is tax on lands and buildings. Entry 49 talks on lands, talks on taxes on lands, it's plural. Lands and buildings, again plural. Lands, now this judgment, 9th judgment said, it includes mineral bearing lands also. It includes any land and every land. You come to entry 50, it takes taxes on mineral rights. There is a qualification, subject to limitation imposed by Parliament by law relating to mineral development. So that means entry 50 is open to some restrictions that can come through union government, through list 1 possible. Because mineral development, we just know, so it is part of entry 54 of list 1. If at all, if it has to come, it can come through entry 54 of list 1 possible under entry 50 of list 2. Whereas entry 49, there is no qualification. It clearly says taxes on lands and buildings. There's no qualification. That means the union has got no powers as far as entry 49 is concerned. Absolutely divide. Absolutely divide. Now, in India, the fundamental is land is always a state subject. Entry 18
Yeah.
and probably entry 45 or 42 of list 1. Land is always a state subject. Wherever it is across the country, that's how, because we were under the British regime, then we have moved on. So that even wherever land or land related matters, they are always under the purview of the state government. It is always part of list 2. Now, for example, in a very crude manner, just to drive across the point, if a central government, say an office of central government, say Ministry of Finance, they want to put up an office in Bangalore. Because it's a central government, they can't just come and take any land and put up an office here. No, they need to seek permission of the state government because land is always owned by the state government. If not by a private party, it is always owned by the state government. That is how it has to be looked into. So central government, just because it's a central government, just because they have got certain powers, they can have a branch anywhere they want to. They can't just come and put up an office here. I mean, it's just a crude manner of explaining. So this is how it is. So that is a distinction. And madam, we will discuss more when I come to
Sure.
the detailed discussions in
Sure.
the subsequent slides. Yeah.
Sure. Yeah.
So I will start sharing my screen again. And now we are a little bit moving on to a different track. So things were very fine. So India Cements was holding the field all along till about late 90s. Okay, India Cements was holding the field. Then came this Kesoram Industries matters. Now, what happened in Kesoram is, again, the cess was struck down. Because again, citing India Cements, the cess was struck down by the Honorable Calcutta High Court, local. So West Bengal government, they wanted to levy a lot of cesses. I've listed only road cess and public works cess here. There is education cess, there is some rural employment cess, some 4 or 5 cesses. We'll see it in the next slide. What are all those cesses? So obviously they wanted to levy cess on coal bearing and other lands. Because generally West Bengal has a lot of coal reserves. The focus was coal bearing and other lands in excess of the powers conferred by the state legislation. That is, what is the legislation? Cess Act 1980, and there were other enactments. They wanted to levy with effect from 1st of April 1992. Obviously, the matter was litigated, and who was the litigant? It was Kesoram Industries Limited. Basically, it's a textile division. It's a Birla Group company. So they litigated because they operate certain coal-bearing lands in West Bengal. So they litigated this cess. Again, what is the reason? They cited India Cements and they litigated. They clearly said, no, sorry, the state government has no powers. So matter went before the Honorable High Court. Generally, in mining matters, normally we have a mines tribunal under the MMDR Act, Section 30. There's a concept of mines tribunal. We call it as a revision authority. For any matter, the first recourse is the mines tribunal. After the mines tribunal, we are supposed to go to the High Court and then to the Supreme Court. That is the order. Like in a tax matter, we have the Commissioner Appeals or whatever the first appellate, second appellate tribunal, and then we go to the High Court and then to the Supreme Court. Whereas in the mining matters, we have something called as a revision authority. We also call it as a tribunal and then the High Court. But by and large, 80% of the matters end up in High Courts only. And invariably, under Article 226 and 227, we end up before the Honorable High Court only. The reason being, in the mining matters, inaction of the state government. Even though the law is there, the state government will not be working on it. There'll be enormous delay in sanctioning, in getting permissions. The second issue, unlike tax matters, if any ruling comes, the tax authorities, they are okay. They accept the ruling and they accept the law. There is an amendment, they're ready to accept. But in a mining matter, especially the mining authorities, the Directorate of Mines and Geology or the state government is very difficult. They don't accept any judgments of any other high courts at all. Only if it is the jurisdictional high court, they're ready to accept. But if it is some other high court, they find it very difficult. They are waiting for instructions from the higher authority. Let the secretary tell me. No, you go to the secretary. He says, no, let the cabinet or the government tell me. Or the cabinet will say, no, let it come to mines ministry. So that is how things get delayed. So obviously my operations are impacted. Or maybe I may have to pay certain monies, so many implications are there. Penal consequences will be there. So invariably 80-90% of the matters, the first stage, the first remedy is the High Court only. And especially in Karnataka, we have seen it's all the mining matters in Karnataka are invariably before a division bench. It never goes to a single judge bench here. Unlike in Andhra or other states, in Andhra and all mining matters go to the single judge and then the division bench and then the Supreme Court. Whereas in Karnataka, invariably the mining matter, they are before the division bench and one of the judges invariably will be the Chief Justice of Honorable High Court of Karnataka. That is how things work, at least in Karnataka. Now what happens? So here also probably Kesoram, instead of going to the tribunal, because they know tribunal also, even the orders of the tribunal, the state governments don't care much. It is not like ITAT or now the GST appellate tribunal that's going to get formed. It's not like that. Because it's very, very clear. At least ITAT is very clear. Any order of the ITAT is binding. The lower authorities have to follow. Even in the MMDR Act, revision authorities' orders are binding, but still the state government will take a different position. If nothing is there, they will say, no, I will go file an appeal before the Honorable High Court. That's how things work. So 80-90% the matters are invariably filed at the first instance before the Honorable High Court, only in a mining matter. Okay. Now, obviously, here also the cess was challenged. It was struck down. Again, reason is India Cements. So obviously, the matter was before the Honorable Supreme Court. So it was State of West Bengal versus Kesoram Industries Limited, because Kesoram was a petitioner before the Honorable High Court. In the Supreme Court, he will be the respondent. Now, it was before the three-judge bench. Now, three-judge bench analyzed this whole matter. There were differing views. Then it was referred to a constitutional bench. On 12th of October 1999, the three-judge bench said, no, let us refer it to a constitutional bench. Constitutional bench is minimum 5 judges or above. So here it was referred to a 5-judge bench. It is, as given the citation here, the decision came in Kesoram Industries matter on 15th of January 2004. That means after 1989 or 1991, the next decision in all the cess or royalty matters came only in January 2004. And it was a ruling given in the ratio of 3:2. This was the ruling. What is the ruling? Apart from this, there are also other matters that got clubbed. In fact, High Court of Allahabad, before the ruling came, it upheld the cess, SADA, we call SADA, Special Area Development Authority cells in Uttar Pradesh. It upheld the levy on the minor mineral rules. So there's a mix. There are a bunch of matters. So finally, in Kesoram Industries, the 5-judge bench of the Honorable Supreme Court, they said the state legislature is competent to impose cess or tax. They said there was a typographical error in the earlier 7-judge bench of the India Cements. They looked into the judgment of the India Cement because that was the leading case then. So they said, no, there was certain typographical error in the 7-judge bench of the India Cements order. So obviously there's some error. So that's the reason we rule the states are well within their right. So that is the reason they said cess levied under the Cess Act, education cess levied under the West Bengal Primary Education Act 1973, rural employment cess levied under the West Bengal Rural Employment Protection 1970, whatever, all these 3-4 cesses that were challenged before the Honorable Court, they upheld. They said, no, you can levy. So that means state of West Bengal, they started collecting cesses right from the beginning, right from 1/4/1992. And also they got support in this Kesoram matter and they have been collecting the levies. So the levy was upheld. So what was the error? You go to para 34. They talked about para 34 of India Cement judgment. They looked into the earlier paragraphs. This is exact wordings in para 34. They said the 5-judge bench in Supreme Court, Kesoram matter, they said, they analyzed the judgment. They saw in the second phrase, if you see, we are of the opinion that royalty is a tax. This para 34 in India Cements, the wording was, the second phrase was that royalty is a tax. The 5-judge bench, Kesoram said, ideally it should have been cess on royalty is a tax. That means cess on royalty was somehow missed out. They said there was a typographical error. Ideally, it should not have been royalty is a tax. It should have been cess on royalty is a tax. Now they said this was the typographical error. And they said you go to the last sentence of para 34. They said if you go to the last sentence, it's a little contrary. They said royalty or mineral rights is not a tax on land, but a payment for the use of the land. And the last sentence says royalty or mineral rights is not a tax. Then here, the second phrase in the first sentence, it cannot be royalty is a tax. Ideally, it should have been cess on royalty, but somehow it is missed out. So this is the typographical error. And because of this, in Kesoram matter, they said royalty is not a tax, and that's the reason the levy of cess is upheld. Then obviously, India being India, the states, they did not keep quiet. They found support now in Kesoram matter, January 2004. Now, lot of states, they came up with new enactments. The earlier 11 enactments are gone. They came up with new enactments because they wanted to collect additional revenue. Now, Bihar, for example, soon after 1991 judgment, that old law is gone. They came up with a new enactment, 1992, Orissa, 2004. In fact, this Orissa cess matter 2004, it was actually stayed or struck down by, the Honorable High Court of Orissa. They relied more on the India Cements matter, reason being because India Cements was a 7-judge matter, whereas Kesoram was a 5-judge matter, 5-judge bench matter. So obviously they said supremacy has to be given to the 7-judge. So that's the reason they stayed. The cess levied by way of Orissa Rural Infrastructure Socio-Economic Development Act. Likewise, Chhattisgarh, Madhya Pradesh, Telangana, all of them, they came up with new enactments and they started collecting. Some states they collected, in some states matters were litigated. There were some states granted. So it was a mix and match. Even Jharkhand, as late as 2020, they also came up with a new cess. So now We have cesses continuing. Only in Karnataka, we never had any cess. Because Karnataka said already we have burnt our fingers. So let us not come up with any new enactment. So Karnataka was silent. But other states, they came up with new levies, again, new cesses, post Kesoram judgment. So this was the whole thing. This was the position. Now, obviously, 1989 India Cements, 2004 Kesoram, 1989, 2004. Now, in the meanwhile, in the background, there is another matter before the Honorable High Court of Patna. That was again, SAIL versus State of Bihar. That is nothing but Mineral Area Development Authority. The local authority, they wanted to come up with some cess that was challenged. That was challenged, and obviously, again, the cess was struck down. The cess was struck down. Again, they clearly said, the Honorable High Court of Patna said, entry 49, sorry, it doesn't come under the scope of entry 49. Again, the Patna High Court, the Honorable Patna High Court relied on the India Cement judgment. And if you see the date of judgment, this was March 1999. Mind you, March 1999, that means it was before the Kesoram matter. It was before the Kesoram matter. So obviously, the matter was litigated. It went before the Honorable, Supreme Court. When SLP was filed and converted into civil appeal. On 30th of March 2011, the 3-judge bench of the Honorable Supreme Court said, sorry, there are 2 contrary decisions here, 7-judge India Cements and 5-judge Kesoram. So that is how it was referred to 9-judge bench. So that is how this whole thing was before the 9-judge bench. So from 2011, the matter was pending till 2024, so roughly 13-14 years. Only now the 9-judge bench, because formation of 9-judge benches is not easy. Because some matters I attend, some of the mining matters I attend in the Honorable Court, Supreme Court, it's not easy. Sometimes getting 2 judges also is becoming difficult. So, but somehow we have to appreciate the current CJ. He somehow collated 9 judges. And then he said, no, we are dealing with this matter because matters are quite old. So that is how the 9-judge bench was formulated. And this is a constitution bench, no doubt, because the number of judges are 5 and above. And that is how we have this judgment. We have this judgment. So now I am getting into the actual subject. So till now we have covered only the genesis, how the whole thing was before the 9-judge bench. Now at this stage, if anybody has got any queries, I would like to take it up before I get into the other aspects. I have covered roughly about 30-40% of my presentation. We still have a long way to go. I doubt whether I'll be able to complete. I will be able to complete before 10. All right. Anything to be discussed at this point before I actually get into the topics discussed post these 2 judgments, India Cements and the Kesoram matter. Now the Supreme Court sets the ball rolling. Anything to be discussed at this level?
Vijay sir, till this Supreme Court decision has come, India Cement was ruling, right? Not Kesoram. Because
But the problem is, madam, because we had 2 differing judgments, right? But primarily, yes, 9-judge bench should ideally supersede. But somehow the 5-judge bench took that position, and some of the high courts accepted, like Allahabad High Court accepted, but some high court did not accept. So it's a mix and match. So that means we are again in a state of confusion. We are again in a state of confusion. So this is the whole thing. This is the whole thing. So I mean, this is how the laws are being litigated in India.
Yes.
So no doubt that's how the lawyers have a lot of business, I would say. So,
Yes.
Because
Ideally,
yeah.
ideally, Kesoram should have been referred to 9-bench judge, because what it has done is overruled India Cement, and by number of judges less than 7.
No, Ganesh sir, technically this 5-judge bench, they should not have touched the 7-judge bench, ideally.
Exactly, sir.
Because how can a 5-judge bench, touch the 7-judge matter? Ideally, I mean, if you follow the hierarchy, the jurisprudence, but somehow it happened. And some of the high courts accepted also.
Yeah.
Before and post. So that is how the whole thing, and especially land, minerals, they're all very complicated matters. Now, if you understand further, He will know the difference between surface right, subsurface rights, who is the owner of the surface rights, who has got the legal validity. So many things are there now. So all this we have to discuss and then to arrive at a particular conclusion. Finally, to say whether royalty is a tax or not, and what is royalty, and what about the levies basing on royalty, etc., etc. So this is the whole gamut. So that's the reason we are discussing in detail. So anything else? Any other queries to be discussed
Yeah.
at this level?
Sir, but Kesharam has not touched the principle or concept which India Cement has given. It is only identified the typographical error as per its interpretation.
No, Kesaram said royalty is not a tax. The whole thing is gone. It has broken the spinal cord. It said royalty is not a tax. So obviously, cess on royalty is okay. That's the whole thing. The summation is Kesaram says royalty is not a tax. India Cement says royalty is a tax. To conclude, this is the whole list. So that's the whole problem. So it broke the spinal cord. It never said that decision is wrong. They only, because a 5-judge bench cannot openly say, and that too of the same court, right? Same Supreme Court. They cannot say my producers have done a mistake. That's the reason they took a shelter saying, no, it's a typographical error. So it's a decency also, right? So that's how it is. So, but end of it, they indirectly nullified the India Cements matter by saying that royalty is not a tax.
Which is per inquirium actually.
Yes, I think you can explain more on this incurium business as a lawyer, because hearing that they talk about per incurium and all, so you can probably explain more this concept.
Vijay sir, we already 9:46.
Yeah,
If any questions are there, we'll take. And in the next session, I feel it is better you start going to the case, because another 10-15 minutes, I don't think it is possible to complete. So what I suggest, another 5-10 minutes, we take some questions. And Jatin sir also add some other sessions so we long down.
okay, no problems. Yeah, I think we need one more session because I have about 100 slides, so I've covered about 40 slides so far. So we still have a long way to go. Now the real thing comes in. So all right, we can discuss anything is there at this level. Yeah, I think we can probably call it a day, and we'll resume the next session again. I have no problems.
Any other questions? Anyone?
No, Vijay sir, a request. Can you share the PPT in the group? We can go through the PPT and we will be able to appreciate even better. Thank you for your wonderful explanation.
Yes, madam, it will be shared. No problem. I don't have any IP rights in this. It will be shared. No worries.
Share it now ahead of the next session so we can go through the PPT and we will be able to appreciate it better.
Yes, madam, I will share. No problem. But probably by the time we come to the next session, I would have done some modifications. So to that extent, you'll have to bear with me. No problems, madam. It will be shared. No worries. It will be shared.
Thank you.
Yeah.
Sir, last point, sir, Vijay sir, whether this article 246A was also discussed in this, sir? Because I've not gone into depth of that, but I somewhere read that there is a challenge of article 246A also under GST law. Because this was challenged under the old law, right? So is there anything which they brought an amendment in article 246A?
Madam, 246A they're not touching because
They're
you
not
know
touching,
this
yeah.
246A has come only by way of Constitution Amendment Act, 101
Correct.
Constitution Amendment Act.
2016. Yeah,
I
yeah.
think that's September 2016.
16.
They have
Yeah.
not touched. They have not touched. But yes, 246A, it is somewhere similar to 246.
Yeah.
46, no doubt. But 246, there's a reference to list 1, list 2, list 3. Whereas 246A, there's no reference to list 1, list 2, list 3. Reason being,
Correct.
both can legislate now because that's how
Yeah.
GST has come about.
Correct.
So that is the reason they have not discussed anything on 246A, madam. It is for us to understand because
Correct.
GST, the levy has come not by entries, any entries in list 1, list 2 or list 3. It has come because of 246A direct.
Yeah, I got it. I was just thinking because this was under service tax law, which in 2011 it was pending. And this will be operative in GST law also. So is there anything which will have an impact on 246A? That was my, though
No, madam.
240,
No 246A, but yes, there is reference to entry 97 of list 1.
yeah,
I hope we all know what is entry 97 of list 1, Service Tax,
Yes.
Finance Act
Yes, sir.
1984. So yes, that is there. That has been discussed.
yes,
Very
yes.
thoroughly it has been discussed. Entry 97 has been discussed, but
Okay.
definitely not Article 246A. No, it has not been
Okay.
discussed.
Yeah, okay, sir. Thank you so much, sir. Very informative.
So does that mean it will not have any implication under GST regime, this judgment?
Yes, it will. We will see toward the end.
Yeah.
We will definitely, because we see taxes cannot be seen in isolation, right? We have to see the transaction. See, GST, I always believe, is a tax on the transaction that we undertake. So, depending on the transaction, the nature of levy, the nature of the activities, tax, according to me, is a last resort. But unfortunately, we as accountants, we always think about the taxes. No, first is the nature of the levy. Depending on that, the taxes will be decided. Because, for example, GST is only taxes on goods and services, we all know. But let's say it is on immovable property, then there will be no GST. Now, what this judgment has said, that we have to look into it. Now, what are the conclusions of this judgment? We have to look into it. So, we will come to that also, sir, towards the end, because I need to conclude with GST on all these matters. Otherwise, my presentation is not complete. Because I
Yeah.
am presenting to a GST study circle now. So, obviously, I need to conclude on GST matters. We will do it, sir. Towards the end, we'll definitely do.
Right, sir.
Yeah. So thank you, sir. It was an excellent presentation. The way you presented shows how much in-depth knowledge you have on this subject. And this group is very fortunate to have you on your presentation. And we look forward in the next study circle meet to see what is the implication of this judgment on GST. Thank you, sir. We'll meet next session.
Mailar sir, anything, Jatin sir's final comments?
No, Jatin sir had some other sessions, so just too long. So what we
Right.
can do once we have this judgment analyzed in the next session, so we can ask Jatin sir to give his comments.
Sure.
All right.
Okay.
Thank you. Thank you, everybody, for your
So
patient
thanks a lot.
listening. So,
Thank you.
thank you. Yeah.